Mike Mulvaney, thank you very much for joining us.
Appreciate it.
Thank you.
Thank you very much indeed, John, for that introduction. Thank you, General Barr, for being here. Welcome.
Thanks.
The headline for this conversation is Antitrust and Other Matters. And with your indulgence, there's quite a lot of news, as John said, at the moment. So I'm going to start with the other matters part of the the other matters part of the program. So it may possibly have captured your attention this morning that the House of Representatives published 2 articles of impeachment against the President of the United States. Let me just read out an excerpt from the first article of impeachment, which says that using the powers of his high office, President Trump solicited the interference of a foreign government, Ukraine, in the 2020 US presidential election. He solicited the government of Ukraine to announce investigations that would, among other things, harm the election prospects of a political opponent. Is that not exactly the sort of abuse of power that the founders had in mind when they drew up the impeachment clause of the Constitution?
You put so much work into that question. I feel bad that I'm going to give you the answer.
I had all morning, after all. You could sit.
Which is, there's this political constitutional process underway on the Hill, and the Attorney General is not part of that process. And at this stage, I'm just not going to comment on it.
Nothing at all on.
I will say that on the other article of impeachment relating to obstruction. I don't believe it's the case that where somebody, including a branch of government, is asserting a legal privilege that they have under the law, that constitutes obstruction.
The second article says it was President Trump directed the unprecedented, categorical and indiscriminate defiance of subpoenas issued by the House of Representatives, and given that the Constitution gives the House sole responsibility for impeachment, this is itself represents obstruction.
Well, as I said, I just said what I said, which is it was predicated on advancing claims of privilege that have been previously advanced in other administrations, and I don't consider that obstruction.
So it's not unprecedented? No. Let's move on to the other issue that was occupying a lot of your attention yesterday, which was the publication of the report of the Justice Department's Inspector General, Michael Horowitz, into the origins of and the conduct of the investigation of President Trump and his associates around the Russia allegations about collusion with Russia. Mr. Horowitz, in his report, said yesterday, we concluded that the FBI had an authorized purpose when it opened Crossfire Hurricane, that was the name of the given to the investigation, to obtain information about or protect against a national security threat or federal crime. You said in response to that yesterday, the FBI launched an intrusive investigation on the thinnest of suspicions that were, in my view, insufficient to justify the steps taken. Could you tell us what exactly it is, where exactly you disagree with Mr. Horowitz?
Okay. Well, first let me say I think there's sort of 3 parts or issues, well, I'd say categories of analysis in the report. The first is, was the investigation adequately predicated? The start of it. The second one is, how was it conducted? And I break that down into 2 things. How was it conducted before the election, and how was it conducted after the election? The real meat of Horowitz's work and the real thrust of the report actually deals with the conduct of the investigation, where I think it quickly became apparent that it was a travesty. And there were many abuses, and that's by far the most important part of the report, and I think Mike Horowitz would agree with that.
The abuses, I want to come on to these in detail, but
yeah.
The abuses that in particular refer to the Pfizer application, the application to the Pfizer,
and also the fact that from day one it generated exculpatory information and nothing that substantiated any kind of collusion. But put that aside for a minute, going back to the issue. In many ways, sort of the issue of whether it technically was adequately predicated is something of academic interest only. But Where I disagree, and by the way, Mike knows I disagree with him, and there's still people in this town where you can you can be adults and professionals and have disagreement without tearing each other's hearts out. So it's just one of those things. We have disagreements in the Department of Justice, but I think that the basic, it's a big deal to use the law enforcement and the intelligence resources of the United States government to investigate a campaign of, especially an opposing party. I can't think of I'm sure there were instances in the past, but I can't think of any recent instance where that was done.
And the report does make clear there were concerns about that and discussions at very high levels within the FBI as to the sensitive information, as a sensitive person.
And so, basically the department, as you would expect, the principles are essentially a rule of reason. What is the basis you have for looking into something? And what are reasonable steps to take, taking into consideration the weight of the evidence that's prompting you to do that, the alternatives available, and exactly what you were trying to accomplish, and also the sensitivity of the area involved here, a political campaign, core First Amendment activity. And where I disagree with Mike is I just think this was very flimsy. This was a comment made by a 28-year-old volunteer in a campaign in a bar offhand, which was described as a suggestion of a suggestion.
Right.
And I personally think the subject matter of it, which was the fact, some vague allusion to the fact that the Russians may have something that they could dump, at that time in May 2016, there was rampant speculation going on in the media, on the blogosphere, and in political circles that Hillary Clinton's email server had in 2014 been hacked, and therefore the Russians might have those emails. So drawing the conclusion that this kind of vague comment related to and showed pre-knowledge of the DNC hack and dump, I think was a big stretch. But let me just finalize it, which is, from my experience, the normal thing to do in this kind of situation, and I have had analogous experience here, is to go to the campaign. And here, I don't think there's a legitimate explanation for why they didn't, especially because they went to the Russians.
Well, I think actually in the report, I think it does say that they, that they considered this, but there were concerns that because the campaign, that it would be alerting the campaign. If there was
and my
criminal activity going on, they would be alerting the campaign, and they would be able to shut it down.
Right. And what the FBI person said as to why he didn't is he said, we only do that if we are certain, if there's no possibility whatever that the person is witting of their, and that's simply not true. I mean, I have authorized defensive briefings, and I know of defensive briefings that are regularly conducted. You look at all the circumstances. If your purpose was to protect the election, then you would have done a defensive briefing here, because the chances of people like Sessions or Chris Christie being in cahoots with the Russians were pretty minimal. But if there was stuff going on, then by going in, you brace them and you disrupt the activity in time to protect the election. But it just doesn't hold water, because on August 4th, they contacted the head of Russian intelligence and said, we know what you're up to, you better stop it. They did again in later August, and President Obama did it directly in September. So it doesn't strike me as plausible that you would tell the Russians, who clearly were guilty of interference, but you wouldn't go and talk to the campaign. That makes no sense.
So you believe the predicate was very, very flimsy, essentially. Yeah. You've just laid that out. So why did they do it? Do you think there was some political motivation on the part of people at the FBI or the Justice Department, or mostly the FBI at the time, to go after the Trump campaign in this way?
That's why we have Durham. I mean, Durham is able to look at all the evidence. He's able to not only look at the evidence within the FBI, he's able to require people to testify.
This is the U.S. Attorney in Connecticut.
U.S. Attorney, and he's able to talk to to other agencies. He's able to talk to private parties. There was a lot of swirl of activity going on at this time. It wasn't all in the FBI. So I think he will have a broader appreciation of all the facts, and a determination can be made. I don't know what the motivations were, and I'm not saying they were improper motivations, but I think it's premature to rule definitively there wasn't. Now, in that regard, people have to understand the role of the IG. We are an agency that makes discretionary decisions every day, thousands of them, and the internal watchdog, his general approach, and it's the right approach, and I respect it, is to say, look, if the people involved give me reasonable explanations for what they do, that is, their explanation's not unreasonable on their face, and I can't find any documentary or testimonial evidence that contradicts it, I will accept it. And that's what happened here. He said, I haven't found evidence of improper motive. He did not, as contrary to what a lot of the media is reporting, he did not find there was no improper motive. He didn't find evidence of improper motive.
The evidence of absence of evidence is not the evidence of absence, right? But so Christopher Wray, the FBI director, similarly said yesterday in response to the report, the report did not find political bias or improper motivation. Again, do you challenge that?
No, I'm just saying what the IG found. The IG said, I did not find documentary or testimonial evidence contradicting the reason, the explanations that were given me, and I accepted them. He is not definitively ruling that there was no bias. I think that's why we have Durham.
On the initial investigation, the FBI, again in the report, it says that the FBI saw that, and you referred to that initial conversation between George Papadopoulos and Alexander Downer. It's just referred to in the report as, I love these acronyms, you get FFG, Friendly Foreign Government.
Friendly Foreign Government,
FFG.
We never heard of this Downer guy.
And we also have CHS, I believe, right? Confidential Human Sources and various others. But there was this conversation between Papadopoulos and the Australian, which, by the way, wasn't reported actually for about 2 months, I think, after the initial conversation. But the FBI regarded that as a tipping point, given what it had seen about the WikiLeaks publication, what it knew about the DNC hack already, and that is it not reasonable that they thought, given that they knew there was this extensive Russian effort to intervene in the election, along comes somebody inside the Trump campaign who says, you know what, we've got this information, possibly I've been offered information, possibly, or dirt on Hillary Clinton. Is that not reasonable then for the FBI to go ahead and say, you know what, we probably need to investigate this?
Well, that's why I sort of expounded on this a little bit in the front end. The basic official version is that we thought the Russians were hacking into the DNC, and on July 23rd, WikiLeaks dumped DNC emails. Then a foreign official comes in and says, back in May, this guy said something in a bar to me. It was a suggestion, and before they even interviewed that person, they opened a counterintelligence investigation on the whole campaign, on the idea that this must reflect pre-knowledge of the hack. I'm saying that when you actually look at the surrounding circumstances, that was a bridge too far. I mean, it wasn't reasonable for them to assume that, and the proper response was to talk to the campaign. That's normally what would happen. This happens all the time in campaigns. Foreign donors through straw donors, and there's hanky-panky going on. And usually we don't assume as the government that the campaign is part of that plot. We go in, we say to the campaign, hey, they're foreign people that are feeding money into your campaign and so forth. So the idea that you only talk to some American that is involved here, if you are 100% certain that they're not culpable, is simply not true.
Just very quickly on this, because we do want to move on to other things, but on the Pfizer application in particular, again, the report is very critical. Documents 17 omissions or errors in either the initial or the 3 subsequent applications to the Pfizer court for surveillance of Carter Page, as we know. The report does say it resulted in Pfizer applications that made it appear that the information supporting probable cause was stronger than was actually the case. Do you think that, given that actually those Pfizer applications should never have been made?
Yeah, this is the meat of the issue, and if you actually spend time to look at what happened, I think you'd be appalled. Remember, they say, okay, we're not going to go and talk to the campaign. We're going to send people in, wire them up, and have them talk to the individuals. That happened. That happened in August, September, and October, and it all came back exculpatory. People say, I don't know, don't know what you're talking about. Not only exculpatory as to a relationship with the Russians, but as to the specific facts. And that, A, they never did anything about that. They just pressed ahead. But B, they never informed the court. They were told they didn't have probable cause to get a warrant, and so they took the Steele dossier, which they had done nothing to verify, and they used that to get the warrant, to just collapse everything. They withheld from the court all the exculpatory information, and they withheld from the court information about the lack of reliability of Steele. The real interesting thing here, and to me the major takeaway, actually is after the election. Because in January, they went to, Steele was dealing with one person. You only talked to one person. And that's what we call the primary subsource. And it was that person who had the so-called network of subsources. When they finally got around to talking to him, he said, I don't know what Steele's talking about. I didn't tell him this stuff. Or, it was mostly barroom talk and rumor. I made it clear to him this was my own suppositions and theories. And this is, and at that point, it was clear that the dossier was a sham. So what happens? What happens at that point? They don't tell the court, and they continue to get FISA warrants based on that dossier. And more damning is that they actually filed with the court a statement saying, we talked to the subsource, and we found him credible and cooperative. And they put that in to bolster
when the subsource had actually said
what he was being truthful about is that the dossier was garbage.
It was nothing. Yeah.
So it's hard to look at this stuff and
just very quickly,
not think that it was a gross abuse.
Let me put it another way. Do you think the judges, the 4 separate FISA judges in those courts, were badly misled?
Yes.
Just final question on this. The report also says this was a failure not only of the operational team in the FBI, but of the managers and supervisors, including senior officials in the chain of command. Are people going to be held accountable?
Well, they're all gone.
Do they need to be held? Is there some? I mean, you've mentioned obviously the other investigation that's going on.
I think that's.
Is that up to and including Jim Comey, Andrew McCabe?
I'm not going to speculate, who, but.
Do you think they're implicated in that statement?
I've said that I think that that group, there was a failure of leadership and I'll just quote the IG. I mean, the IG says that the explanations he received were not satisfactory. Now, when you have the kind of rank behavior that involved, and the IG says he doesn't get an explanation for it, you can draw your own conclusions from that. But here I want to say that one of the things that's poisonous about our politics is the use of the criminal law process as a political weapon. And both sides, to some extent, are guilty of this, and instead of just debating ideas, they want to label their adversary as a criminal, and they, pore over the U.S. code to try to find some kind of esoteric argument as to why what someone does is a crime, and then get in a criminal investigation. And then they start calling for scalps. So, nowadays I'm constantly hit. Why aren't people going to prison for what they did to the president? And on the other side, throw Bill Barr in prison. And these things take time. At the end of the day, we're all protected by the fact, and this is something I'll get to if you want to talk about white-collar crime.
Yeah, I do.
Which is...
We've talked about nothing but white-collar crime so far, actually, but I think you're talking about a different sort.
What protects all of us is that the government has to have proof beyond a reasonable doubt, at least under Justice Department standards, before we indict anybody. And that's a pretty substantial hurdle, and no one is going to go to jail, and no one's going to be indicted unless that standard is met. And I know a lot of people, and also, they think if I don't like someone and I don't like what they did and I'm morally outraged, send them to jail. And why isn't this person being indicted? And that's, sort of poisoning the system.
Very quick question, finally, before getting on to antitrust. On the Ukraine issue, the famous July 25th phone call between President Trump and President Zelensky, which is the cause of this impeachment proceeding that we're seeing today. There's a quote in there where he says, President Trump says to President Zelensky, there's a lot of talk about Biden's son, that Biden stopped the prosecution, that was of the Ukrainian prosecutor, and a lot of people want to find out about that, so whatever you can do with the Attorney General would be great. It seems horrible to me. Did the Ukrainians do anything with you?
No.
Nothing at all?
No.
No follow-up at all?
No. And also, that's taken out of context, just to be fair. I mean, in the president's call, he started out by talking about the abuses in the 2016 election that he said our country has paid a heavy price for, and he asked him to work with the Attorney General on that. Now, the fact is, I was smart enough not to get involved with the Ukraine. At least put it very low on the list.
Are you contrasting yourself? Are you contrasting yourself with Rudy Giuliani by any chance?
I'm just saying that that hadn't reached the top of my to-do list yet, and so fortunately I hadn't looked into the Ukraine situation. But he then later in the conversation gets into other things, and then he starts throwing different names around. But the fact, as I've said at the time, I've had no dealings with Ukraine. I've had no dealings with Rudy Giuliani about Ukraine.
It does raise the question, why was this never a U.S. investigation? The allegation was that a U.S. citizen was perhaps corruptly acting with a Ukrainian. Why was all the pressure was on the Ukrainians to at least announce an investigation? Why would that not be a matter for U.S. investigatory authorities? At
the time, I don't know whether it was or not, frankly.
Antitrust. It has been widely reported, I know you can't talk in detail about it, that the Justice Department, that Antitrust Division, is investigating big technology firms. I know you've had a strong interest in this over the years, both in the private sector and now in your role. A big investigation. Meanwhile, the FTC, we know, is also investigating. There seems to be bipartisan support in Washington to do something about what is seen as the dominant position of big tech. Again, I know you want to talk about the details, but first of all, just ask you the timing on that investigation. It was announced over the summer. Are you expecting any kind of imminent resolution? Can we expect it sometime next year? I
don't want to sort of predict that. We started in earnest in July. It's been moving very quickly. We have a very ambitious schedule, and things are keeping up to schedule. We're talking very broadly with people and getting a lot of input from people in the industry and experts and so forth. And we're doing our analysis. And, I'd like to have it completed sometime next year. I think it's important to move quickly on things. That's something I can talk about later. But these things have a cost to the marketplace and to the businesses, and I think at some point the government has to fish or cut bait.
What are the principles here at stake? I mean, obviously bigness alone is not, these are enormous companies, they dominate their sectors, they dominate the US economy and the markets in this way, but that it's well established that scale alone is not sufficient to warrant antitrust enforcement action, or even to raise necessarily concerns about unfair behavior. So what would be the without getting into it again, what are the concerns about what Google, Facebook, Amazon, Apple, maybe others are doing?
Well, let me just say, our review is not just limited to antitrust. Antitrust obviously is front and center. But there are also other concerns relating to these companies that other laws might apply to. There's some pressure, or some people have suggested sort of strong-arming the antitrust laws in order to reach things that really were not intended to be covered by the antitrust laws, and I'm not really in line with that. I don't mind updating, making sure that we're properly applying the antitrust laws to new situations, but we are looking at antitrust. We're also looking at behavior across the board and how it implicates other laws. The problem, obviously, is big, and I said this at my confirmation hearing, big is not bad. I work for Verizon, and I really appreciate that. But the question is, when you have the kind of market power that some companies have in their market, then some conduct which may have made sense when they were sort of the insurgent company in a growing industry can become anti-competitive because it ends up fortifying the monopoly. And so there's conduct that has grown up in these businesses that we have to take a look at and see the extent to which it really involves maintaining a monopoly. Also, this is particularly true where you have powerful network effects like you do in these sectors. The other thing is that these are businesses that operate in multiple submarkets, and you have to do a lot of thinking about how they potentially are leveraging power in one into another, and also the role that data plays in that.
So a couple of the issues again, you may or may not want to comment on them, but some of the things that people have raised concerns about are things like, for example, bias in search results, that they could be, the algorithms could possibly, conceivably, be favouring either their own products or people who've paid or whatever. Is that a possibility? Is that something you're looking into?
Well, I can say exactly what we're looking into. I think Google has made public that they received civil investigative demands, but I think it's sort of apparent to everybody the kinds of practices that are potentially being looked at.
And that could be one. And what about the simple scale of the online advertising? Facebook and Google between them dominate online advertising. Is that in itself, the scale that they have, is that a source of concern and potential antitrust action?
Well, that goes to the market power, and then you have to look at particular practices that may essentially exclude other competitors and lock in their market power. As I said, just successfully competing and getting to a dominant position is not itself wrong.
What about the use of data? I mean, there's an intriguing article, by the way, in the Wall Street Journal just published today that points out that maybe while Facebook and Google may defend themselves on the grounds that they're not raising prices, it's all what they provide is free, and actually they provide a tremendous benefit. There is this interesting new argument, I think, in antitrust that actually what they are doing is, in a sense, they are charging consumers by using their data. And that is, if you like, a cost to the consumer, not a non-monetary cost perhaps, but a cost to the consumer that their data is being used, and that itself could represent exploitation of a monopoly in a way that is unhealthy and potentially in breach of antitrust. Is that an argument? Is that a theory that you're open to?
I'm inclined to think there is no free lunch, and something that is free is actually getting paid for one way or another, and so I am open to that argument.
Could one solution there be that maybe people have suggested that people should be paid for their data? That I'm happy for Facebook to use my data, but it has a value, and I should receive compensation for it.
Yeah, I don't want to start talking about potential policy responses. I think the public interest or the consumer interest standard is broad enough to reach not just issues of pricing, but also practices relating to so-called freebies. But as you said at the beginning, one of the interesting things about this issue is the bipartisan support for the issue. I found that out going around. It was the only thing that some people were civil to me about during my confirmation. But we have 50 states.
You and Elizabeth Warren are exactly the same page as far as I think so.
But 50 state AGs have now coalesced, and we're working with all 50 state AGs. Now, for those of you who have had companies dealing with state AGs and coalitions of state AGs, it's a pretty difficult situation when you're in a business. But there's complete consensus that something should be done, and we're trying to work closely with them. So, if there's a basis for litigation, if there's a basis for other enforcement actions, so be it. But there also may be an opportunity for legislative proposals.
One more quick question on the tech, which is encryption. And I know there's been, again, some consideration of this, and I think your deputy made clear recently that this was part of the investigation. That this issue of particularly end-to-end encryption, which is very, very hard. Obviously, it's designed that way, very, very hard for anybody to crack, and it does have law enforcement implications. Is that something you think needs to? You've already, whether it's with WhatsApp or Facebook Messenger, is that something you want to address?
I mean, that's one of our highest priorities and something I've talked about a lot. Basically, we're not concerned about the kind of encryption is good in that it enables, the commercial use of the internet. We're not talking about encryption, in dealing with your bank or a vendor or something like that, because the government with a warrant can go and get the information it needs from the vendor or the bank. What we're talking about is consumer products that provide end-to-end encryption like WhatsApp and Signal and other things. Criminal organizations, and I'm talking about terrorist organizations, drug cartels, child molesting rings and kiddie porn type rings, are moving to encrypted end-to-end apps, which completely defeats the ability of the government to get in there. So we have increasing number of horror stories about how people are dying or being molested or whatever that we cannot get into. We know it's happening, but we can't get into the communications. This also goes to telephones. We can pick up a terrorist telephone and not be able to get into it. So, fortunately, sometimes we get into it, but not all the time. And we're talking, by the way, about no diminution in privacy. What we're talking about is when you actually have a warrant based on probable cause that a crime is being committed, you cannot get the information. And I sort of sum up the whole thing this way. These businesses are essentially selling this. They're basically saying to people, hey, we can give you the protection against any scrutiny from the government whatsoever. No matter what you do, you are completely impervious to government surveillance. That might sound good to the individual, but do we want to live in a society like that where everybody is absolutely insulated from any government scrutiny, even when there's probable cause to believe that crime is underway? I don't think we do. So,
one broad question on antitrust. A feature of the US economy in the last 25 years has been a dramatic increase in concentration in sector after sector. Number of mergers and acquisitions, companies going under. There's been a recent survey said that I think 75% of US industries had seen a significant increase in concentration from 5 to 4 companies or 4 to 3 companies. And there's tons of evidence that this is harming the consumer. You look at things like broadband, for example, a very good example. You know quite a lot about this, I'm sure. There were 2 or 3 major companies providing broadband services, 2 or 3 major companies providing cell phone services. There's a very interesting new book out by an economist at New York University, which estimates that the prices in these areas, cost to the consumer in these areas, in these sectors of the economy where there is this concentration, is significant. And he compares US concentration and US prices to prices in Europe. We don't think of Europe as a particularly competitive market particularly, but for example, average price of broadband in the United States is $68 a month. In France, it's $31 a month. In Italy, $30 a month. Cell phone use, US $100 a month. EU, it's about half that. Whether you dispute the figures or not, there's been this dramatic concentration of sector after sector, with plenty of evidence that it's harming the consumer. Do you think there needs to be a fundamental review, either through antitrust? Obviously, antitrust will be an obvious way to do it, but somewhere else, of actually examining these and restoring some degree of competitive pressure to many of these sectors?
No.
Just not. You don't think it's a problem?
I don't think you can make that kind of general statement across all business and all sectors. I think it's a sector by sector, market by market analysis to see, to assess concentration. I think some markets actually benefit from concentration, some degree of concentration.
Which markets?
Telecom. No,
well, maybe the companies benefit from these data the consumers don't see.
I think in certain network industries you can be too balkanized, and no one has the scale necessary for the kind of innovation that we're seeing. And also, I think it's sometimes hard to assess technological change. So 5G sort of changes the whole idea of broadband availability and so forth. I think you have to look at it sector by sector with an appreciation of technology. I think back when I was at Verizon, people were still, looking at it as, they wanted to, increase the number of competitors on telephone by essentially converting the local phone companies into wholesale platforms that everyone else glommed onto it at discounted prices. And the regulators were, spending all their time on that. Meanwhile, what happens? What happens is IP protocol on cable, which then immediately turned the cable companies into competitors. So, and now we have, wireless and so forth. So I think it's a sector-by-sector, market-by-market analysis, and I think some markets benefit from a few players. Some may, require more.
Quick couple of final questions because we're running out of time. You were Attorney General almost 30 years ago, 25 years ago, first time around in the first Bush administration when you were, what, 15 years old, something like that? Was it? Yeah.
41, yeah.
You're back.
Let me just say that my view on this thing is that there's only people who should be Attorney General are people who are too young to know the risk or too old to care.
Well, we won't decide which category you're in, but just what's your, and then you worked in the private sector, you've talked about it a little bit for most of that interim period. As you come back into the, you've obviously been somewhat hit by all these impeachment and other related issues and the investigations and everything else, but as from the point of view of business, what you've seen from outside the Justice Department, from outside government in the last 20 years or so, what do you want to do, and you've doubtless had to deal with the Justice Department in various roles in many ways, what do you want to do, what needs to be done, do you think, especially from the perspective of this business audience, to make that experience of dealing with law enforcement fairer, more effective, maybe more transparent? What are your priorities there?
So my view is you shouldn't work in a senior position in the Department of Justice unless you've spent a lot of your time on the outside dealing with the Department of Justice. So a number of things. Number one, time. I think there's a risk at the department and other agencies, they think they can take forever on their matters, and they do, and they come in, sort of like day after day in the case, or it's like their rice bowl for the next 5 years, this investigation. My attitude is fish or cut bait. The government, that has huge cost to the government in terms of opportunity cost for you to be, excuse the expression, dicking around with some case that really isn't getting anywhere. And it's very costly to the private sector to be under this kind of cloud. So I want to make sure that people purposefully address a case. There's someone who's sensible who can look at it and say, is this going to get anywhere at the end of the day? Are we going to be able to prove a crime beyond a reasonable doubt? And if we're not going to be in that position and it's disproportionate amount, are we going to move on to the next thing? So I'm impatient with, sort of the backlog of cases and the average life of cases. Another issue is, esoteric legal theories. Enforce the law in the core meat and potatoes area where the law is supposed to apply, and don't come in here with some kind of esoteric application of the law just because you can catch the company. The other thing is, let's face it, companies are like shooting fish in a barrel. Very few companies are going to go and take the risk of a trial. And so over the years, a state of mind has arisen where, you get the company over a barrel, you just get, it's a question of how much money you're going to get. And so we've adopted the policy that in order to come in to resolve a case, the prosecutors have to come in with a trial plan. They have to show that they can establish beyond reasonable doubt all the elements of a crime and what witnesses they're going to be able to call to do that. They're going to show they have to do the work to say that we can prove beyond a reasonable doubt that this company is guilty. Now, if a company rushes in, the day after they're caught and says, hey, man, we want a DPA and, we're willing to pay anything, I'm not saying that we wait until we develop the case. Okay, you want to deal, we'll deal. But if a company's being held up on something that's unjust, we want to put the prosecutors through the ringer that they actually have to have the evidence and be able to prove beyond a reasonable doubt that this is not an extortion of the company. Those are some of the ways that I'm trying to address it. Now, there's a lot going on, and I can't give this my undivided attention, but this is one of the reforms I'd like to see.
Final question. You gave a speech a few weeks ago which attracted a lot of attention, the University of Notre Dame Law School. in which you talked about the centrality of religious liberty in the United States, in its history, in the mind of the founding fathers, and those traditional religious values, and how important they are to a fully functioning, free democracy. You actually said that traditional religious values are under threat, under the target of organised destruction. You said people are attacking traditional religious values, whether it's over, requiring, Catholic institutions to provide contraception for their employees, or the LGBT rights for others, of people, organisations that maybe disagree with, don't accept those. Now, this attracted a lot of attention, as I say, particularly on the left. You got a lot of criticism from liberals. The New Yorker actually called it the worst speech by an Attorney General in modern history, which you must have sort of badge of pride. There must be for you a bit there. But can you just give us just it's our final moments, a little bit more about what why you think religious freedom is under threat, and why it's and what you particularly as the Attorney General of the United States perhaps can do to defend it and to restore it to its central role in the U.S. in the U.S. Constitution, the U.S. life.
Well, legally speaking, there used to be a consensus. There was, just 10 years ago, 15 years ago, that there should be an accommodation of religion. In fact, that passed overwhelmingly in Congress, and Chuck Schumer was the co-sponsor of it, and I think Teddy Kennedy and Hatch were involved. And which is, maximum accommodation to religion. Religion is a good thing, and we may have a general rule, but if it steps on somebody's toes, we try to accommodate it. That's gone by the boards, and now we almost, some people seem to take delight in forcing particular groups to accept, something that is anathema to them. I think humans have lived with religion for and evolved with religion for 50,000 years. I think regardless, and I'm not saying it's just a utilitarian thing, but it has been a very important part of our ability to live together in a community, and our founders believed that they could provide the kind of freedom they did in this system precisely because they felt that the moral values that people had primarily from religion, they'd be able to control themselves, so we can give them maximum freedom. And that if they don't have that, then society becomes more and more tyrannical and starts making all the rules. And I feel that there's been a breakdown of self-control, and that the government is performing the role of sort of alleviator of the consequences of that, essentially subsidizing irresponsibility and misconduct. So we're getting more and more of it, less and less self-control. And, government is, facilitating that. And I think we'd be better off to take a more neutral and a more accommodating position toward religion, not a position of hostility to religion, which I think, the Constitution has been misinterpreted to.
Some of these issues are big executive for chief executives. We had a session this morning. Chief executives are increasingly, demanded to take public stances on some of these issues in ways that a lot of religious people object to. Is that a threat to the religious freedom values that you're talking about?
What do you mean?
Well, they're under threat. For example, they're strongly under pressure on a lot of these issues of social concern, whether it be LGBT rights, for example. That some people may object to those. They may find it very difficult to have that, a religious view which is consistent with what you. But it does seem like the prevailing atmosphere these days requires chief executives to embrace rights that maybe, and we have seen some of these religious clashes, come along with, the stuff that sort of Chick-fil-A has been going through, or some of these other issues. We're seeing, more and more pressure on companies. Some people regard it as a good thing, but what's your view?
I guess my view is, I don't think it's a good development to have, all these social warriors, essentially pushing companies to take positions on these kinds of things. Those are companies that do, that's fine. I mean, that's the choice, and if the shareholders are happy, that's fine too. But what I was saying is, and I think I said this at my confirmation, it's one I personally do not believe that gay people should be discriminated against in work. That's not currently in our law, but I have no problem with that. I think that's the right thing. But on the other hand, I think there has to be accommodation so that if a Catholic school system doesn't want to have, a gay person who's living in a single-sex marriage as a teacher, they should be able to say that. So my attitude is live and let live, and there has to be space for different, real diversity. When people talk about diversity, they're not really talking about diversity. I want real diversity in our society. I want people to, to be able to form their own communities and live according to their values. And I think there is a group in our society that's, views their mission as going around bludgeoning everyone into uniformity. And almost, and I said in my Notre Dame speech, it's a little bit like the Roman Empire where, the Christians were good citizens. I mean, they were the best fighters in the Roman army. And
no match for the lions, though, were they?
No, yeah. But that was later. That was earlier. But I mean, and yet they wouldn't let the Christians. Many of the emperors would not let the Christians live in peace. They weren't satisfied unless they actually got up and sacrificed to the emperor as a god. And you sort of feel a little bit of the same spirit nowadays. Is that unless the little sisters of the poor provide contraception, okay, there's something horrible and outrageous going on in society, and I don't like that.
And we'll have to leave it there.
Thank you very much indeed, ladies and gentlemen. Please join me in thanking the Attorney General. Thank you very much. Enjoy.
And reaction from House Republican leadership to the articles of impeachment coming up.